California is a regulatory minefield when it comes to classifying employees versus independent contractors. There are several different tests that are used by different agencies in order to decide what the proper classification is. On a basic level, employees are on your payroll, they're under your control, and they work for you mostly on a daily or consistent basis, while an independent contractor is not your employee, and your relationship is based on contract law. Let's talk first a little bit about the benefits of hiring an independent contractor and why a small business owner would want to do this. So, one of the first benefits is cost saving. You save money from mandated contributions, such as unemployment and Social Security. Also, you save costs from benefits like medical leave, sick time, or retirement plan participation. Labor laws are inapplicable, like the Fair Labor Standards Act when it comes to minimum wage, overtime, break periods. They're not going to apply to an independent contractor because they're not your employee. Also, it reduces the risk of discrimination, wrongful termination, or unemployment claims. Again, these are only available to employees. Now, when you work with independent contractors, you want to make sure that if you make any payments that are above $600, you need to report that and give them a Form 1099 at the end of the year. Now, what are some of the cons of having an independent contractor? Well, number one, loss of control. You are a client of the independent contractor, not an employee. Therefore, you cannot control the way that they do their businesses, when they provide their services, how or for how much. This is something you agree to in a contract. Also, you can't terminate without cause. California is an at-will employment state, so for employees, you can terminate them at will. With an independent contractor, it's different. You have a contract for their services, and you can't simply terminate that relationship without potentially opening yourself up to liability for breach of contract claims.
Long time no see. All right, so at this point, you've learned about the difference between LLCs and corporations, the incorporation process, trademarks, and now we're getting into the nitty-gritty of employees versus independent contractors. This is such important information. Failing to properly classify employees versus independent contractors is a big deal in California. You'll learn all about that in this module. What I want to focus on right now is this idea about working with independent contractors being on a contract basis. So a lot of entrepreneurs get confused when it comes to working with an independent contractor. They start treating them like an employee, and they assume that they can fire them like they would an employee. That's not the case. You have to abide by the terms of your contract. So let me tell you a story about a green manufacturer here in California. This manufacturer had hired independent sales representatives to work for the company. They are independent contractors. Their job is to go out and get sales to sell the products. But they run their own business. They are independent. They are not employees. So you can't terminate them. You have to enter into an agreement. Now, the client did enter into an agreement, but he failed to really consider the implications of that agreement and the terms that he should put in there. Eventually, the relationship unfortunately turned sour with one of the independent sales representatives, and he was talking badly about the company, sort of talking to their customers about the issues as he saw it within the company, and the company didn't know what to do about it. You can't just fire them like you would an employee. When they looked at their agreement, they realized that they hadn't really left themselves much leeway to walk away from the contract. They hadn't put provisions that said, we can cancel this contract immediately if you don't sell a certain amount of product, for example. We can cancel this contract immediately if we feel that you're not doing the right thing for the company. Not only that, when it came to the provisions on the term of the agreement, it automatically renewed every year. So the renewal period had come and gone, and they didn't have to discuss it. They didn't have to re-sign an agreement. He just automatically had another year. If they would have noticed the renewal period was coming up, they may have been able to terminate the agreement before that point, but because they didn't, it was automatic. The guy had a whole other year working for that company in spite of the fact that the sales were not good and he was beginning to be a real problem. So that's just one example of how this can go awry. The worst part is when they tried to speak to him about it, it only made matters worse. He began to threaten other members Ultimately, we were able to get him out of this contract because the behavior became so extreme. But it made me think, what if someone was kind of just walking on that line? Not exactly doing something enough to say, hey, we're being threatened or this is a serious danger to the company, but enough for you to be losing money and losing time. You got to think about these things when you hire an independent contractor, how long you're hiring them, and what ways you can get out. What is your exit strategy if things don't turn out as you expect?
Also, there's a lack of continuity and an ongoing relationship. Of course, with an independent contractor, they're going to work on their time and when they're available. And in fact, that actually increases the defensibility of claiming that they're an independent contractor if you don't really have control over how that relationship continues or how ongoing it is. Also, clients bear the risk of misclassification. This means that if you're the hiring entity and you classify someone as an independent contractor when they're truly an employee, you're the one that could be open to liability and even penalties. Finally, in line with that same topic, you need to monitor the legality of the relationship. You have to make sure that when you're working with an independent contractor, you don't actually start blurring the lines with an employee. So, different government agencies are going to apply slightly different tests when they're deciding when somebody is an employee or not. So, although there is a lot of overlap in these tests that we're going to discuss, you do want to sort of understand the differences and when they apply. So, the first main test is called the Dynamex test or the ABC test. This applies with the EDD for unemployment and disability and whether you're required to provide that, and the Department of Industrial Relations, for wage and hour, overtime, and break periods and whether that's actually going to apply. So here are the 3 questions that are going to be asked under the ABC test to decide if somebody's an employee or an independent contractor. 1. Is the work free from control? Again, you should not be controlling how the independent contractor does their work, what the nature of the work is, where they are going to do the work. That's free for them to decide on their own as a separate business. 2, is the work performed outside the usual course of the business? This one has kind of thrown California business owners for a loop. It basically means that an independent contractor can't do the kind of work that is typical and ordinary in the course of your business. So, for example, if you own a restaurant and you want to hire a cook as an independent contractor, well, you're going to fail the test on this second question because being a cook in a restaurant is within the ordinary and usual course of that business. So it really limits business owners when it comes to hiring independent contractors. And third, is the contractor customarily engaged in work of the same nature? That basically means that you're going to want an independent contractor that isn't only working for you. They're customarily engaged in that business and they probably do it for several other clients as well. So that's the Dynamex ABC test, which is the newest test that's been applied in California. Now we also have the second test, which is the Borrello test. This one has been around for a much longer time. It's also used by the Department of Industrial Relations when it comes to workers' compensation and whether or not you need to have it, and the Fair Employment and Housing Department when it comes to anti-discrimination laws and whether you can be sued by an employee for anti-discrimination. So the Borrello test actually applies a multi-factor test. No one thing is going to decide the definition. So they're going to look at whether you control the contractor, similar to Dynamex. They're also going to look at whether you supply tools for the work, or the length of time that they're working for you, as well as the method of payment. Finally, can you fire them at will? No single factor controls when it comes to the Borrello test. And unlike the ABC test, the Borrello test was not incorporated with an eye towards social welfare. Instead, it's a statutory test. You should be aware of both of these and keep them in mind when you're trying to classify someone as an independent contractor. So, at the end of the day, independent contractors are a really important and useful tool for business owners. It allows you to leverage the specific capabilities and skills of a certain individual and apply them to part of a larger project or an entire short-term project. You just want to be aware that the IRS, the EDD, the Department of Industrial Relations are not bound by your own classification. So just because you choose to call someone an independent contractor doesn't mean these government agencies are going to respect that classification. They're going to want to make sure that you are complying with the legal definition of an independent contractor if you want to avoid liability, back taxes, and even penalties. Since the Dynamex case in California, which created the ABC test, the burden to prove that someone is an independent contractor has now been placed on the hiring entity.